Welcome to another video episode produced by Kerrville United, moving Kerrville forward. I'm your host and producer, Aaron Yates. Up until now, almost all of our videos have been about your city government. We are an all-volunteer organization here at Kerrville United, so we don't always have the resources or time available to cover everything we want to. And up until now, we haven't covered the Kerr County government much at all. That changes today because we observe some activity that is troubling, and we want you to know about it. First, let's set the scene. If you follow our site, you already know about the animal shelter policy changes that happened on October 15th. The Commissioners Court, a group of 5 elected officials that oversee all aspects of county government, held a meeting on October 15th and issued an order to change the days of operation at the shelter, the operating hours, and the volunteer policy. This action was met with consternation by the animal advocacy groups, prompting several letters to the editor, editorials, and articles on Kerrville United. Since then, the commissioners have set a public town hall-style meeting for November 18th to discuss these matters. As a side note, we've asked permission to film that meeting and bring it to you in its entirety so that you can see and hear for yourself the arguments for and against these new policies. We await word from the county on whether or not we'll be given permission. But we applaud the commissioners for holding that meeting. But what really interested us about the October 15th meeting was the process by which that order occurred. The item as presented on the agenda called for executive session, in parentheses, but the agenda item itself didn't sound like something that would qualify for a closed-door session. You see, the state of Texas sets forth really specific laws about what can be done behind closed doors. The Texas Open Meetings Act is the name of the law that all elected officials have to be very familiar with, and by default says that almost everything a government does has to be accessible to the public. Meetings have to be posted at least 72 hours in advance, all documents have to be available via public records requests, and meetings and decision-making has to be done in public, not in private. The law does make some exceptions for sensitive matters. Things like security procedures, litigation, contract negotiations, and personnel matters can be discussed privately in what's called executive session. During those parts of the meetings, a government body meets without the public present, but they can only discuss the specific matters that called for them to adjourn into executive session. In other words, it's illegal to say, hey, we're going into private to discuss A, B, and C, only to then go on and discuss X, Y, and Z. I have some personal experience with this law. As a member of Kerrville's EIC, I have been in executive session when someone brought up a topic that was not the topic that brought us into the closed meeting. When that happens, the city staff or the city attorney present will stop the discussion and say, hey, you can't discuss that in here. You need to go back into public session if you want to talk about that. So these laws are well understood by all elected officials and by citizens that serve on these government boards, and they're taken very seriously. In fact, we have to go through a very long training video and read a bunch of documentation to prove that we know what the Open Meetings Act is all about and how to abide by it. So what exactly happened at the Commissioners Court meeting on October 15th? We saw how the agenda item was a bit vague and how that item didn't seem to fit into the categories for a closed session. However, when the item came up, the Commissioners Court did go into executive session to discuss it. According to the county attorney, the legal justification to go into closed session was cited as section 551.074 of the government code. That section allows for closed session discussions of personnel matters. Wait, what? The agenda item didn't mention anything about personnel matters. It just said they would discuss and take action on the Animal Services Department. This was the first clue that something wasn't exactly right. Guidance on 551.074, the Personnel Matters exemption, specifically tells lawmakers that closed sessions should only be used to discuss specific employees, not a class or a group of employees. The Texas Attorney General's Handbook on Open Meetings and the Texas Municipal League's Handbook make it very clear that personnel matters have to be about specific employees, not about general policies relating to a group of employees, and certainly not about policies relating to how long a facility is open and on what days. Regardless, this was the county's justification for holding deliberations where you, the public, couldn't see them. And when they came out, the court voted unanimously to change the hours, change the days, and change the volunteer policy. No action on personnel matters. Something is very wrong here. But since the executive session minutes and/or recordings can't be released without a court order, we thought that we could never find out what exactly was discussed behind closed doors, even though we had a pretty good idea. And then, an aha moment. We found an Attorney General's opinion from 2007 that says that all the notes or reports or other records created or used in executive session are not protected from public records requests. That is, if anyone took notes about the discussion, those notes could be given to us if we asked for them. So we asked. Sure enough, we received a response. The Kerr County Attorney, Heather Stebbins, an elected official that sits in on executive session proceedings, took notes during that closed session, and those notes were provided to us. In those notes, she writes that the commissioners discussed non-personnel related matters such as animal adoptions, photos of animals, phones in the kennel area, limiting the number of volunteers to 3 at a time, implementing more specific volunteer procedures, comp time, the website, closing on Saturdays, and staff lunches. All of these things have nothing to do with personnel matters as defined by 551.074 of the Open Meetings Act. We should note here that as County Attorney, Heather Stebbins does not have any control over what the commissioners actually do. She is there to give advice when asked, but cannot force them to make the right decisions as far as executive session, open sessions, or anything else. We should also note that she has been very responsive and helpful with our requests for information and has been nothing but fully transparent with us throughout this entire process. So let's pause and recap. Commissioners decided to go into closed session to discuss personnel matters, and some personnel matters were no doubt discussed. But they also discussed all of these things that are not personnel matters. They did all this in private so that no citizens could hear or participate in the discussion. What should they have done? Well, remember when I told you about my personal experience in executive session? When the personnel matters discussion was over, they should have gone back into public session to discuss all of the other policy matters on that list. Was this a sensitive and emotional topic, the animal shelter? Absolutely. But just because it's politically difficult to discuss openly does not mean that it's legal or ethical to withhold that discussion from the public. This action represents a breach of the public trust. It may be a violation of the Open Meetings Act. Our elected officials must have the confidence and trust of their constituents to do the right thing at all times, whether it's politically beneficial to them personally or not. We believe that the county should apologize for this error in judgment, and to prevent future lapses, we think adding a video recording system to all public meetings would be a huge step in the right direction. After all, sunlight is the best disinfectant. Read more about this matter on our website, www.kerrvilleunited.com. This is Aaron Yates for Kerrville United. Thanks for watching.